Story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Frankie Rose's Think Tank. Here's your host, Frankie Rose.
Hey guys, welcome to the Think Tank. So we spent today streaming the Jennifer, oh my word, I'm tuckered. So we streamed today Ethan Crumbly's mom, Jennifer Crumbly. So it was a pretty long day. We did about an 8-hour stream, but well worth it. There's lots in there. So check that out. Hello, 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 Maxie. How you doing, friend? So, I appreciate all this as well. Thank you. Join the Think Tank and follow on Twitter. Much appreciated. I like that. A little tickle, ding dong, that notification, and subscribe. Well, hey, James, good to see you. Welcome, welcome, welcome. My lord. So tonight we're going to take a look at Richard Allen. I've been a little bit behind now that I've been trying to do some, well, hello, Dave. Good to see you. Wow, good to see you, friend. So yeah, a little bit behind since we started doing some trials, but I tell you what, they're pretty darn interesting as well. So yeah, we are going to catch up with Richard Allen and what's been going on there. There's some documents out and a couple of different things that, I'm a little bit surprised at, actually. Hey, Carrie, good to see you. On your first coffee. I am just winding down. Yeah, it was a long stream. So, yeah, there's a couple things that, not that I disagree with them, I'm just kind of surprised to see it. And one of it is they're still trying to get Gull gone. And you know what? I cannot disagree with that. I really can't. How difficult can it be to go through this at the Supreme Court and then have to work with her again, knowing, in my personal opinion, that she doesn't really like you. So let's take a look. It's probably not going to be a long stream. There's also out is oh my goodness, the amended, let me see here, affidavit. And I'm going to take a look at that. And I want to look at it against the other one at the same time. So I'm not going to go through that tonight. So Delphi suspect Richard Allen accuses judge of bias and asks her to recuse herself. She's a stubborn one, guys. Ooh la la. The contentious relationship between Delphi suspect Richard Allen's attorney and special judge Francis Gull again took center stage on Monday's filings for Gull to step away from the high-profile case. Yeah, it makes sense to me. Nobody trusts her anymore. The court's conduct demonstrates the court's inability to remain impartial to the defendant Allen and further demonstrates that this court has engaged in judicial conduct that undermines all public confidence in the independence, integrity, and impartiality of the court. Allen stated in an affidavit he signed on Saturday and that was filed on Monday that was a motion to disqualify her. What do you guys think? How easy are they going to work together? I just don't see this happening without an appeal coming around. Allen is accused of deleting Libby German and Abby Williams. Now, this was back on February 13th, 2017. The girls were taken from, they're saying abducted, and fair enough, from the hiking trails near the Monon High Bridge east of Delphi. According to the prosecutors, he is charged with 2 counts of M while taking, and 2 counts of taking. That's what he looked like when he first went in. Remember that? Once upon a time? Doesn't look like that now. So Ellen's attorneys, Brad Rossi and Andrew Baldwin, motion for Gull's removal, cited an affidavit from Ellen's touching on how Gull appears biased against the defense. Based on her public rulings, the filings come out just 11 days after the Indiana Supreme Court reversed Gull's October 31st order forcing the removal of Rossi and Baldwin. That was just a shite storm. So we know that Richard Allen was totally against this, and they literally had to take her to the Supreme Court in order to get it figured out that Francis Gull was wrong. If the Indiana Supreme Court concluded that Judge Gull wrongfully denied Richard Allen of the attorneys he is choosing, would then an objective person have a reasonable belief that she, Frances C. Gull, is biased and prejudiced towards defendant Allen? A motion rhetorically asked. Gull removed Rossi and Baldwin on her own initiative, claiming they were grossly negligent and incompetent. Hello, Chopper. Good to see you. Yeah, romper room addicts. Yeah, great way to put it there, Dave. She called an October 19th hearing at the Allen County Courthouse, but she met with the attorneys in her chambers without providing Rossi or Baldwin advance notice of the issue at hand so they could prepare for the hearing. Allen's affidavit states inside Gull's chambers, she forced Baldwin and Rossi to say they would resign rather than Gull making a public declaration about them. Now, if I remember correctly, she just basically said that she would say that they were insufficient counsel and had to go. The affidavit that they filed on Monday accused Gull of then making statements to the public and on the record that misrepresented the in-chambers hearing, calling her statements untruthful as to the withdrawals of Baldwin and Rossi. She put them in a position. She did. She cornered those guys. The affidavit also cited that when Gull removed Rossi and Baldwin, 2 outstanding defense motions were pending. The motion for the Franks hearing to publicly vet the credibility of law enforcement officers, statements to get a search warrant at Allen's house, and a motion to suppress evidence found in the search. The motions have been pending for months without the court's action when Rossi and Baldwin were forced from the case. So in November, Gull twice noted that if the attorneys who replaced Rossi and Baldwin wanted a hearing on these 2 matters, she would set a date according to the motion. So I'm not sure which one it was of her 2 replacement lawyers, but one she was close personal friends with. I mean, they were Facebook buddies. That tells you a lot. Drive safe, Dan D. So, however, within days of Rossi and Baldwin being reinstated, Baldwin wanted a hearing on these 2 matters. She would set a date according to the motion. However, within days of Rossi and Baldwin being reinstated, Gull denied the motion for the Franks hearing and denied the motion to suppress without a hearing. So she's just doing whatever the hell she wants again. Monday's affidavit states, along with other allegations against Gull, including ex parte communication, absolutely, with Carroll County prosecutor Slick Nicholas McClelland, and favoring the state. Yeah, she's done some pretty sideways-ish. I mean, there's no denying it. The test is whether an objective person, knowledgeable of all the circumstances, would have had a reasonable basis for doubting the judge's impartiality. The motion states about Gull's decision, noting that a reasonable person might question Gull's decisions. At every stage, from now until the conclusion of this case, the actions and the rulings of the court will be scrutinized through the lens of Judge Gull's error in severing Richard Allen's attorney-client relationship with his chosen lawyers. The attorneys also argued that Gull remaining on the case could lead to a successful appeal if Allen is found guilty. Well, that is the thing, right? I mean, they're giving great reasons for them to appeal. I personally don't think she belongs on there anymore. I don't trust them. I'm for removing this judge if we can have this trial start, let's say, by tomorrow. Yeah, and I mean, boy, to be fair, there are horribly biased judges in this case. I am more with the judge, but if it would speed things up, she should have stood down. Well, and nobody trusts her, you know? Absolutely, Dave. If I was part of the victims' families, I would be angry. Oh, yeah, like pissed. Oh, my God. So we're going to take a look. This is the state of Indiana, county of Carroll, state of Indiana versus Richard Allen. Verified motion to disqualify. Comes now the accused Richard M. Allen by his attorneys, Bradley A. Rossi and Andrew J. Baldwin, and pursuant to Rule 2.4 of the Indiana Rules of Criminal Procedure, or RCP, and Rule 211 of the Indiana Code of Judicial Conduct, CJC, and respectfully move for a change of judge from Judge Francis C. Gull or her recusal from the case. In support of said motion, Richard M. Allen swears and affirms the following. 1, the filing of a motion for disqualification and or request for recusal strips the court of jurisdiction to decide on any matter until a ruling on the disqualification motion occurs. 2, pursuant to Indiana Criminal Rule of Procedure 2.4b, the state or defendant may request a change of venue from the judge only for bias and prejudice. This motion must be accompanied by an affidavit signed by the defendant or prosecuting attorney. The affidavit must set forth facts and reasons for the belief that bias or prejudice exists. If the defendant signs the affidavit, the defendant's attorney must file a certification that the attorneys believe in good faith the facts recited in the affidavit are true. The court must grant the request if the facts recited in the affidavit support a rational inference of bias or prejudice. Emphasis added. But put another way, the facts contained in the affidavit show there is reasonable basis to question the judge's impartiality toward Richard Allen and his defense team. 3. Okay, what is that? concomitant with RCP 2.4b is Rule 2.11 of the Indiana Code of Judicial Conduct, which requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned, such is the case in the cause of action. The rule on disqualification and the canon on recusal both adopt a threshold of reasonableness, i.e., would an objective person have the reasonable basis doubting the judge's impartiality? I say so. I think there's a lot. Oh, good Lord. I'll be right with you guys. I'll get into the back. Just a pain in the butt, that one. Good job, Mexi. We got this. He's just a little freaking dickwad. Okay, so I'm sorry, I'm just going to get back to this. So the comments to Judicial Conduct Rule 2.11 provide additional guidance as follows. 1, under the rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraph A and I through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. 2, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. 3, a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there's no basis for the disqualification. Oh, Francy Gull, or the beach chicken, she needs to flock off. 5, the test under the canon is whether an objective person knowledgeable of all the circumstances would have reasonable basis for doubting the judge's impartiality. The question is not whether the judge's impartiality is impaired, in fact, but whether there exists a reasonable basis for questioning a judge's impartiality. The legal standard is not lofty. 6, the accused has a federal due process right and unbiased judge under the 5th and 14th Amendment to the U.S. Constitution. Judicial bias is one of the narrow classes of constitutional violations that implicate structure error. Cases of judicial bias involve a denial of the most fundamental constituents of due process. So fundamental that a conviction in the absence is indeed if the defendant is plainly guilty. Structural errors render a criminal trial fundamentally unfair and are not subject to harmless error analysis. Here, there is no recognizable legal rationale which supports Judge Gull continuing to preside over this case. At every stage, from now until the conclusion of this case, The actions and rulings of the court will be scrutinized through the lens of Judge Gall's error in severing Richard Allen's client relationship with his chosen lawyers. She's just out. I don't know. I think it's, in my personal opinion, it's fairly obvious that this woman doesn't belong here. She's already been raising ish, and he doesn't matter if we think he's guilty or if we think he's innocent, he does deserve a fair trial. You know, with her there, I do. I think it's just a given that they're going to appeal and they might win. She needs to go home now. So the preamble, I know he is, in my personal mind, James. I agree. But I still think in order to get something to stick, you've got to follow all of the set structure. You know what I mean? She's leaving room, I think. So let's see here. Through the preamble to the Code of Judicial Conduct provides that judges should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. Well, hello, Wolfie. That's a really good question, by the way. So the court has already interfered, with one of the most sacred concepts in our Constitution, the relationship between attorney and client. There can be no dispute that this has occurred. The highest court in the state of Indiana has cemented this fact. If the Indiana Supreme Court concluded that Judge Gall wrongfully denied Richard Allen of the attorneys of his choosing, wouldn't then an objective person have a reasonable belief that she, Frances C. Gull, biased and prejudiced towards defendant Allen? Judge Gall should recuse herself and in doing so restore any sense of impropriety that is clouding the system of jurisprudence in the state of Indiana and in this very proceeding because of the judge's prior actions. The recusal of Judge Gall would be entirely consistent with the spirit and foundation of Canon 1 and Canon 2 of the Code of Judicial Conduct, both of which are founded in the concept of judicial impartiality and fairness. Judge Gall, continuing to preside over this case, necessitates that the following questions be asked. A, will Judge Gall's continued involvement create built-in reversible error in the event that defendant Allen is convicted? And I'm going to mute, guys. Give me 30 seconds. Jasmine. Okay. Okay, so B, will all future rulings of the court be viewed by the defendant as tainted with bias, prejudice, and lack of impartiality? I say so. C, will the public be able to maintain any sense of confidence that the presiding officer, Judge Gall, is unbiased or impartial? I doubt it. D, can Judge Gall process any information and or legal arguments offered up by attorneys Rossi or Baldwin, knowing that she already made an extrajudicial finding that both attorneys have demonstrated gross negligence and gross incompetence in their representation of defendant Allen. Does Judge Gall have some ulterior reason or motivation driving her unwillingness to recuse herself from the case? That's a really good question. F, do the practical benefits of recusal far outweigh the inherent risks of Judge Gall remaining on the case, especially as it relates to the likelihood of protracted and expensive litigation throughout the remainder of this case in the appellate courts if a conviction occurs? And that is the thing. Oh my word. Let me go check the back again, guys. Yeah, just buy. Good job, JJ. Okay. So 12, accompanying this motion is the affidavit of Richard Allen setting forth facts and reasons why defendant Allen believes that a rational basis for questioning the judge's impartiality exists. The same affidavit sets forth the facts establishing the timelines of defendant Allen's request for a change of judge pursuant to. They give us the code. And finally, this motion is also accompanied by a certification. My tongue is doing the thing. It's been one of those, it's been a long day. And finally, this motion is also accompanied by a certification that Richard Allen's attorneys believe in good faith the facts recited in the affidavit are true and accurate. That Richard Allen's signature a couple of times, Bradley and Rozzy, other way around. And they're saying I certify that I have served a copy of this document by the court's e-filing system to the Carroll County Prosecutor's Office the 28th day of January, 2024. So there's that, right? You guys are going to have to let me know. What do you think? Should she still be there? Okay, so we're going to take, let's see here. Okay, so we'll take a peek at this. Do this again, yeah. Jeez. Good Lord. Ew, Mexie's here. Bye, Tristan. Just like that. It's very true. Innocent people go to prison from shoddy police work. That's not good either. Yeah, well said. They did. I agree with that. They made a huge mistake keeping Gull on as judge. I agree. Yeah. All righty, let's take a look at what we've got here. Okay, so we'll just I'm going to close that down and we'll look at another document. Okay, so this is the state's response to the defense's motion for transfer. Now comes the state. Okay, I just want to see. This here was January 29th, so yesterday at 8:21 a.m. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully informs the court that the state has no preference of where the defendant is held pre-trial. But the state believes it is in the best interest of this case as an officer of the court to inform the court of exaggerations and inaccuracies outlined in defense's third motion to transfer. The state would ask the court to consider the following. One, the charges were filed against the defendant Richard Allen on October 28, 2022 for 2 counts of M. 2, that the Carroll County Sheriff's Department requested that the defendant be transferred to Indiana Department of Corrections for safekeeping and was granted at hellhole. The defendant was transferred to Westville Correctional Facility on November 3rd, 2022. 4, the defense filed an emergency motion to modify the safekeeping order on April 5th, 2023, which was denied. 5, that the defense has filed a motion to reconsider and requests for due process hearing on May 3rd, 2023. 6, that a hearing was held after which the court denied the defense's motion to modify the safekeeping order, stating that the allegations advanced by the defense were not supported by the evidence presented. The court added that the defendant was being treated more favorably than other inmates housed at the Westville Correctional Facility. You know what? She comes out with this quite often, but she's forgetting he hasn't been convicted yet. Why is he in a prison? The court made a finding that it's reasonable and necessary to house the defendant at Westville Correctional Facility to ensure the defendant's safety to prevent serious bodily injury to himself. The defense then filed a verified motion for immediate transfer of custody, alleging additional mistreatment of the defendant at Westville Correctional Facility. So we just can't forget that when he was at Westville Facility, that this is how he showed up in court, right? So something's going wrong somewhere. Again, take a look at Koberger and look at this guy. They both did evil things. What the what? What the what? So once again, the court stated that the defense's assertions were factually inaccurate and were refuted by the evidence that the state provided, therefore denying the motion. 10, that the Department of Corrections and transferred the defendant from Westfield Correctional Facility to the Wabash Valley Correctional Facility, where Keegan Kline was hanging out. 11, that new counsel for the defendant has now filed a third motion to transfer. His new attorneys had done that. Not them, the new attorneys said, get him the hell out of Wabash. 12, that the state has no opinion where the defendant is housed during the pendency of this case, as long as he is kept safe. However, the state believes that it is imperative for the court to have accurate information in order to make its decision, which is lacking from the defense motion to transfer. 13, the counsel for the defendant referenced the emergency motion to modify safekeeping order filed by prior counsel and how they find the allegations in that motion merit or meritorious. Is that how you have meritorious? No merits. That the motion has already been litigated at length at the court, found the allegations outlined in the motion were without merits. 15, counsel references a letter written by inmate Robert Baston at Westville stating that the defendant was being mistreated as a fact to be taken as true. However, prior counsel subpoenaed this inmate to testify at a hearing, and the inmate refused to leave his cell to attend the hearing. That's telling a story right there. The state has documented Robert Baston's history with the court in prior hearings and filings with the court. The allegations by Robert Baston are not reliable evidence provided as sworn testimony, nor has he been subjected to cross-examination. 16, that the counsel for the defendant reasserts the defendant is being mistreated by guards at Westville who were practicing Odinism. Now, do you remember, guys? They were walking around with like badges, Odinist badges on them. They were asked to remove them, but the fact is they were doing that on a government uniform. So let's see here. 17, again, this issue has already been addressed in previous motions and was found to have no merit, and the motion was denied. 18, that the defense then make the allegation that the defendant was denied recreational time and showers while at Westville Correctional Facilities. 19, that the defendant has never been denied recreational time or showers at Westville Correctional Facility. This is a believe who you want, and sadly, I'm not believing the facility. 20, that the defendant was moved from Westville Correctional Facility to the Wabash Valley Correctional Facility. He made statements about deleting himself. As a precaution, he was examined by mental health professionals, and they determined that he should not be given recreational time until they can be sure that he won't harm himself. Once he is off that watch, his recreational time resumed. Once he was off that watch. 21, the council next complained that the check-in process at Wabash Valley Correctional Facility is too burdensome and time-consuming. 22, that the state was able to review video footage from council's visit with the defendant at Wabash Valley Correctional Facility. Counsel for the defendant arrived at the facility at 12:35 p.m. and were processed to visit with their client by 12:58 p.m. Then the wait time was extended on this date due to power outages at the facility, but in total lasted about 23 minutes, not the nearly 1 hour allegation alleged in the pleadings. Okay. 23, that the facility typically does not allow face-to-face visits, but did accommodate counsel and set up the defendant in a special room seated behind a door that was see-through and that had a slot for documents, papers, or whatever could be passed back and forth. See photographs attached, states Exhibit 1 and 2. That a surveillance camera was present in the room that records movement only and no audio recordings. The only thing that was recorded from the visit is when counsel entered the room and when they left the room. That to the state's knowledge, any jail that attorneys visit to meet with their clients is video recorded or monitored in some fashion. So is that true? That you don't have attorney-client privilege? That is for the protection of the attorney and the defendant. 25, that neither attorney brought a computer with them to provide the defendant with review of video or audio discovery, even after DOC made accommodations for them to do so. 26, the defense were told by legal counsel for the DOC that if they needed anything additional to meet with their client to just ask, and the accommodations would be made for them. 27, that each request that counsel for the defendant have made of Wabash Valley oh my God, correctional facility has been granted. 28, all this is to say that the allegations that the defense outlined are exaggerated and misleading. They are able to meet with a defendant, show him discovery in whatever format, and meet with him in an effective way. This seems to be more of a motion about convenience for them instead of a zealous representation of the defendant. I think what they're saying is he's like way the hell away from them, and that it is difficult to add all of that travel in on top of getting time for a good talk about the case. So 29, that the state pulled the records from Wabash Valley Correctional Facility, spoke to legal counsel for the Department of Corrections, and reviewed the video surveillance from Wabash Valley Correctional Facility, and the allegations put forward by the defense are inaccurate. So this is the state, right? 30, that the defendant has a tablet in his cell and he can communicate with his counsel at any time, and has said tablet since has been there and has had said tablet since he has been in there. 31, that in addition, since the motions have been filed by the defense, the DOC has set up video conferencing so the defendant can now meet with his counsel via video. That the defendant has commissary in his cell where other inmates do not. 33, that the defendant is being treated far better than any other inmates at the DOC. I just can't say it enough, but he's not convicted yet. 34, that the state also spoke to Sheriff Dan Mahor for Adams County, and he is not willing to accept the defendant into his facility. What? He does not have sufficient space or accommodations to house the defendant. The Adams County jail also does not have the mental health professionals available to address the defendant's mental health needs. 35, that the state spoke to Sheriff Troy Hirschberger at the Allen County, and he is willing to accept the defendant in his facility, but only at the expense of Carroll County. However, the Allen County Jail is currently overcrowded, and Sheriff Hirschberger would have to make special accommodations to house the defendant. In addition, the Allen County Jail does not have face-to-face visits. All visits are done via video, including attorney visits. 36, that the defense continues to make unfounded allegations supported by insufficient proof. 37, that the Carroll County Sheriff's Department does not have the manpower to transport the defendant or the room to house the defendant in a manner that ensures his safety. 38, that the Carroll County Jail does not have the mental health counselors or counseling to address any unaliving concerns that have been ongoing. 39, that once again, for the third time, the colorful, dramatic language used in the defense is an attempt to curry public favor for their client and try this matter in the public eye instead of in the courtroom, as has been a repetitive pattern in this cause. 40, that again, the state has no opinion on whether the defendant should be housed awaiting trial, as to where the defendant should be housed awaiting trial, but the state does take offense to the defense once again filing a motion with this court that is full of inaccuracies and allegations not supported by sufficient evidence in order to influence this court to move the defendant. 41, that the state has no objection to the defendant being moved to a facility within the Department of Corrections, but the court has already addressed that issue in previous orders. Okay. 42, that the defense is consuming the limited resources of his office and the court with repetitive motions that lack any factual basis. I don't know. I think they've got a really good case here. Like, what do you guys think? I think she needs to be gone. Wherefore, now comes the state of Indiana by prosecuting attorney Slick Nick, Nicholas C. McClelland, and files their response for the defendant's third motion for transfer and would ask that the court to consider the same when making its decision and for all other just and proper relief in the premises. Slick Nick, Nicholas C. McClelland, prosecuting attorney. And again, certificate of service saying that this was sent to the defendant's attorneys on the 29th day of January 2024. So this, I guess, is where he slides his documents and food through. State's Exhibit 1. Not a great view, no, but there we go. So yeah, that would be how he's communicating at this point. Okay, so let's see here. So this is just one page, but let's take a look. State of Indiana, County of Carroll, State of Indiana versus Richard C. Allen. And this is from the 28th, 2 days ago. Certification of Richard Allen's attorneys comes now. Attorney Brad Rossi and Attorney Andrew Baldwin, and as required under Indiana Rule of Criminal Procedure 2.4b, certifies that they believe in all good faith that the facts recited in the affidavit of Richard Allen are true. You know, it's just an ish show the way things have gone, you know, and you can't feel any worse for a family that has to deal with the passing of these two young girls and then have to watch an IS show all around it. Let me see here. Okay, so we've got one more, and this was filed on the 27th. State's motion to compel discovery. So this one is 3 pages. And again, State of Indiana, County of Carroll, State of Indiana versus Richard M. Allen in the Carroll County Circuit Court, and gives the case number. Let me see what's okay. State's motion to compel discovery comes now that the state of Indiana, by its prosecuting attorney, Slick Nick, Nicholas C. McClellan, and respectfully requests the court order the defendant to comply with Indiana Supreme Court Rules of Criminal Procedure 2.5 and, oh, hang on, guys, there's somebody cruising by. Jazz. All very good points. Yeah, all really, and the thing is he has admitted to it. Yeah, and could there be somebody else involved? That would not surprise me even a little bit. I mean, I can't eliminate Keegan Klein out yet. I just can't eliminate him. So let's see here. Previously, Carroll County local court rules and support states the following. Okay. 1, that the charges were filed against the defendant on October 28th, 2022. 2, that the court granted a motion by the defense. Hold on here for a second. Okay, just need to check my volume. Okay, so 2, that the court granted a motion by defense for a discovery deadline, ordering the state to produce discovery by November 1st, 2023. 3, that the state complied with that order. 4, that Carroll County local court rules direct that all discovery is to be exchanged between the state and the defense automatically and continuously. 5, that effective January 1st, 2024, the Indiana Supreme Court issued rules of criminal procedure wherein Rule 2.5 discovery states that the parties must endeavor to share information without court involvement. Subsection C, disclosure by the defense states that within 30 days after the prosecutor's disclosure, the defense must furnish the state with the following material and information within the defense's possession or control. A, the names and last known addresses of person who the defense intends to call as witnesses with their relevant written or recorded statements. The defense may refrain from providing a witness's address or any other contact information under this rule. If the defense is in good faith believes that the disclosure of the witness's address or other contact information may jeopardize the safety or the witness's immediate family, hell no, don't dox them. Good Lord. Hey, night night, James. Thanks for being here, friend. Later skater. Okay, so let's see here. The defense does not disclose the witnesses. B, any books, paper, documents, photographs, or tangible objects that the defense intends to use as evidence. C, any reports or statements of experts made in connection with a particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons that may be used at the hearing or trial. 2, the defense must disclose any statutory defense in writing with the statutory deadline, or if there is no statutory deadline, within a reasonable time. 6, that to date, the defense has neither turned over any discovery nor have they provided the state with a list of expert witnesses that they intend to call at the trial or at any other pretrial hearing. They've got their jobs back, man. Give them a second, give them a breath. I'm sure if they get this judge out of there, even, I mean, Slick Nick, whatever, but get that judge out of there and then just let it take its natural course. And I'll be surprised if he's not guilty. I mean, that would shock me. But still, the defense has to have a fair playing field. If not, we're looking at all types of all types. For him to just roll up on kids at random seems super aggressive. Well, I tend to think that there was somebody letting him know. That's my thoughts. So let's see here. That despite requests by the state for defense to disclose any exhibits they intend to use, yeah, that's what I was going to say. They've been pretty busy dealing with all this stuff, with trying to get their client back and arguing with the judge and blah, blah. Slick Nick, there's been no interruption on his side. The state believes the defense intends to introduce expert testimony, exhibits, and evidence at the pretrial hearing and at trial. That the state intends to depose all defense expert witnesses and or other witnesses in preparation for pretrial hearings and jury trial, but cannot do so without the full disclosure as required by the rules. So do you guys think Slick Nick has handed over all his stuff? Wherefore, the state of Indiana, by prosecuting attorney Slick Nick, Nicholas C. McClelland, requests an order to compel discovery by the defense within a reasonable time, not to exceed 30 days, and for all other just and proper relief. So are they doing the same? Are they going to share the same? So again, signed by Nicholas C. McClelland, and the undersigned certifies that the copy of the foregoing instrument was served upon the defense attorney of record through personal delivery, ordinary mail with proper postage affixed, or by service through e-filing system, and filed with the Carroll County Circuit Court this 26th day of January 2024. So yeah, there's that, right? There's that. Yeah, I don't think that anything was random. I just don't believe it. If it walks like a duck and it walks like a duck, it's a guilty duck. For him to just roll up on kids at random seems super aggressive. I wonder if they somehow knew in advance to catch them there. I do, and this is exactly as Mexi is saying. The theory is, at least my personal theory, is that Keegan Klein does come to play, you know, and possibly his dad. I mean, just my opinion, but there has to be something that made him aware to be there that day, because he had things with him that he had taken. He knew where they were going to be. He went down that trail with his head down, no eye contact. I don't know. Is there someone else in the mix I haven't heard about? Well, I'm not sure. There's a lot at play here, because there was, throughout the years, there were other people that were looked at. So I do expect the prosecution to be bringing that up at one point. It cannot be a coincidence that Keegan Klein messaging Libby the night before the 13th. No. And they're also saying that they somehow believe that he got her to delete all these apps and these messages. I recall that there were voices on the video, but I didn't know that anyone had been associated with this besides Alan. Yeah, there's been a few over the years. Like, I would, there was Ron Logan, the guy who owned the property where the girls were found. He was looked at. He passed away from COVID here a couple years ago. A couple other guys that were predators that were looked at, justifiably so. And, everybody, they couldn't find a connection. So when you get on to Keegan Klein, now they have said that he broke open one of the largest rings in the US. So what does that mean for this case? Did he get interrogated and brought in, Keegan? Oh, yeah. He's sitting in the Hooskow. What did he get? 42, 43 years for the crap he had on his phone? Yes. You see, and Keegan Klein had a Dropbox. So who else had access to this Dropbox? Right? If it walks like a duck, quacks like a duck, it could be me. You don't think so? KK is not involved? I mean, there's a really large playlist on Delphi, Wolfie. Check it out. There's lots of information in there and some good deep dives that Mexi and I went in. Oh, maybe this Keaton guy is the guy. I guess that's why people aren't 100% Alan is the guy. Yeah, he's not the guy on the bridge, because Keegan Klein is a big, big guy. And like Mexi just said here, there's no connection that we can find yet to Richard Allen or Keegan Klein. They lived close in proximity. So I would say if RA was going to know anybody, it might be Keegan's dad, Tony. I think Ellie lied to KK in the interviews, hoping he would step in it. Yeah, because they did live in the same area. And like I said, Keegan's dad, Tony, is the same age. And allegedly, he is as disgusting as his son. He was definitely in contact with Libby the night before. Absolutely. So over the last couple of years, there is a lot of documents on Delphi, a lot of just different stuff. So do make sure to check out that playlist. There is a lot to be learned. Oh, my word, Wolfie, there's so many red flags. If Ellie had knowledge of a meetup with Libby, he would have been charged with red rum. Yeah, I'm not so sure they've got the proof. Yeah, yeah, I don't think that they necessarily had the proof, but they did have proof that Keegan Klein talked to her. So pretty weird to be talking to a predator, for a young girl to be talking to a predator on the phone the night before something happens to her and her friend. And the next day they totally get attacked by a different predator. I mean, I suppose it could happen, but I just don't see the likelihood. But with that said, also, guys, there's still a lot to learn. There's still information that's been out there since 2017 that I know a lot of us haven't even been able to dig up yet, let alone everything else that has happened. But yeah, I don't know that they would be able to be charged for red rum. I don't think that. I think there's, what would you say? There's a hook missing. There's something missing in there. And I think once they figure out what that is, heads are going to roll. It's what I personally believe. And we've all seen what that area is like as far as different things that have happened. And Keegan Klein is about 33 now. Yeah, something is missing. Good on you, Chooch. Damn straight, mister. So am I, Dandy. It has been way, way, way too long. Has anyone actually seen the actual text that KK supposedly communicated with Libby? No, but I know law enforcement has talked about it. Oh, hell no. He shouldn't be talking to little kids. No, 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 no. And whatever his involvement was, his case alone broke open a ring of sick, twisted shites. So we know what Keegan was into. We know what all of his charges were. He pled guilty. I mean, and he also points people in the direction of his father. He will also say, like, there's someone else, there's something else, there's something else. And without saying it so much, he's saying it. So, I mean, I honestly can't say that that he is 1,000% involved. I can't say that. But, oh yeah, he does. Oh, do you? You believe that it wasn't planned? Yeah, yeah. I mean, there's a whole bunch of difference of opinions when it comes to this, and we all look at different stuff. BP, not BM, BP. But he does talk about speaking with them. So he admits talking to Libby. He does too. It's unfortunate, more common than I'd like to think. Leave the children alone. Damn straight. Damn straight. I believe Becky Patty when she said it wasn't planned. I don't know that Becky Patty would know. Although I adore that lady. I adore that lady and her family. The only time I heard LE talk about communication with Libby was during that interview. Go through some of the transcripts with Keegan Klein, and he even talks about it. He admits talking to Libby. So I'm sure I've got them in the playlist, friends. So yeah, check them out. Becky Patty wasn't on the trails. Yeah, Becky Patty wasn't on the trails. She was at home waiting for those girls. So yeah, I mean, we're all going to have different opinions. We're not going to know the truth for some time, the way I'm seeing it. And yeah, Becky Patty, I've even had a conversation with her, and I've had a conversation with Libby's sister at one point. They're great humans. But I mean, we're all going to have our own opinions, and everybody is equally entitled to share their opinions, and my personal opinion. None of us know anything 1000% right now. So we need a trial. We need a trial. So guys, that's what I have right now. There is more. I have got some more documents. I'm going to go through the original indictment versus this new one because I want to see the difference between the two. So yeah, with that, guys, have a great evening. Thank you for hanging out with me today. It was a good long day. So thank you again. I appreciate you, and I'll see you guys in the next one. Bye.